The judgment of the Supreme Court in Prashant Bhushan's case is a sad day for the court, and especially for all of us who have participated in this court for the last so many years and have known no other court. The court is everything that is dear to us, and if Mr. Bhushan's two tweets can bring down the authority of the court, then the court is not as strong as we imagined it to be. Contempt is a double-edged weapon. When used correctly, it can at times restore the authority of the court, more particularly when its specific orders are disobeyed. But when the contempt jurisdiction is used to silence, or is seen to be used in a manner that stifles free speech, then it does not add to the authority of the court. Those two tweets, in my humble opinion, may have been in bad taste, may have been unwarranted criticism, but they were certainly not obstructive of the due process of law and the justice which the Supreme Court administers. They were in no way an impediment to the functioning of the court. Today, the conviction has put Prashant Bhushan in the same company as EMS Namboodiripad and Arundhati Roy, whose criticisms of the court also led the court to conviction. Equally, harsher criticisms of the court by Mr. P. Shiv Shankar did not lead to his being punished. The question that any subsequent reader of contempt law will ask is there a rationale between the court's exercise of its contempt jurisdiction in the cases of P. Shiv Shankar on one side, Arundhati Roy, EMS Namboodiripad and Prashant Bhushan on the other? Does the court recognize the powerful? Does the court reserve its harshest contempt judgments for those who speak against power? This is a question which constitutional lawyers and lawyers of contempt jurisdiction are bound to ask. I suspect that the answer really lies in having a relook at the contempt jurisdiction to ensure that it is used only to enforce specific orders and judgments of the court. Otherwise, criticism of the court, no matter how harsh, no matter how unwarranted, no matter how biting, is best answered by the court reaffirming the faith that the public has in it by just continuing to do its duty without fear or favor. Before I go, I'd like to just tell you all a story from the Calcutta High Court. There was the excise classification matter dealing with skin and hides. The judge did not get the difference, and he looked at the lawyer and said, Mr. Counsel, what's the difference? The counsel looked right back and said, my lords, when I was a young lawyer, I had skin. Now I have hide. I think by the time that judges come on to the Supreme Court, they should have a sufficiently thick hide and broad shoulders and the ability to say नहीं है खिताब ज़माना गम के काबिल, तेरा जवाब यही है तो मुस्कुराए जा। थैंक यू।